The views expressed during today's webinar are those of the speakers, not of Stratford, the speakers' firms, or clients, and are not intended to provide legal or tax advice. We have gathered a panel to guide estate planners and administrators on managing the legal challenges of firearms in estate and trust administration. The panel will discuss federal gun laws and firearm designations, issues for beneficiaries inheriting guns, in-state and out-of-state transfers, and legal ownership. The panel will also review the use of trusts and other entities to transfer guns legally and best practices to avoid mishaps in the administration of estates or trusts holding firearms. Our panel today includes John Pierce, attorney at the law office of John Pierce Esquire. He is joined by Jamie Smith-Terr, managing attorney at Smith-Terr Legal. Speakers, when you're ready, we'll get started.
Thank you very much. I appreciate everyone that's joined us here today for what I think is a very interesting topic, and one that I think anyone who practices in the estate administration area is going to run into eventually, and that is you have firearms that come up in an estate. And so we're going to walk through a fairly broad variety of topics here today. I will apologize in advance. My voice is a little bit rough today. So if you hear me clearing my voice or I take a drink of water, I do apologize for that. But let's just jump straight into some of the topics here. Of course, I am John Pierce. My colleague is Jamie Terr. We've got a little bit of information, bio information about both of us in the slide decks that you have. Thank you for having us as speakers, and we're going to do our best to make sure that you come out of this more able to handle those unique situations you run into when you are handling an estate and run into unique firearms. We are going to take questions at the end. We also have practice tips that are mixed in as we go through the slides. There's a lot more slides than we can completely cover during the period of time that we have here. So make sure that you go through the slide deck. We have some statutory references, case information, etc. mixed in there. We're going to talk about as much of that as we can, but some of it we're going to direct you to the slides. Over on the I believe it's the right-hand side of your screen, you're going to see where you can enter questions. If you will enter them, if they're in line and appropriate, we'll answer them as we're doing that section. If not, we'll save them to the end where we will be taking questions. And please feel free to stack up the questions so that we can have a robust dialogue at the end as well. Okay, so we're going to just first of all, just jump into some broad discussion of firearms. Many of you who may already know a lot of the framework here, but just to put it in perspective, under federal law and under most state law as well, and I'm licensed in Virginia, so when I'm talking state law, I'll be talking Virginia. I know Jamie is in Georgia, and she'll be bringing that aspect to it as well. Your states may also have some other unique categorizations, but in general, we break down firearms into two categories: Title I of the Gun Control Act of 1968, and then Title II firearms, which was the original NFA of 1934 and recodified as Title II of the Gun Control Act. So we're going to start off talking about Title I firearms. And what are they? Well, in a layman's terms, we're going to call those ordinary firearms: handguns, shotguns, rifles. And in here, again, I've listed some of the statutory locations where you can look at this, but let's just kind of walk through some of the definitional things that you need to be aware of here. Under both Virginia law and federal law, a firearm includes any device that is capable of or may be readily converted to expel a projectile by the action of an explosive. And Many of you who, in fact, are shooters will understand that explosive is actually sort of an incorrect term there, and the courts have interpreted that as rapid combustion as well. And it also includes the frame or receiver of any such weapon, and we actually had a recent ATF redefinition of frame and receiver that is beyond the scope of this, but you might want to take a look at when you get a chance. A handgun is a firearm that has a short stock. It is designed to be held and fired by the use of a single hand and any combination of parts from which a handgun can be assembled. Again, we find a lot of those type of definitional issues where you can have a parts kit if it includes the necessary parts to be considered a handgun, a rifle, etc. It's going to get swept up into the regulations. So a lot of people run into trouble there. But you may be aware that there's been some recent discussion about arm braces for AR type pistols and whether or not those actually make it so that that firearm is no longer designed to be held and fired by the use of a single hand. There's some regulatory action that's going to be taking place, I believe, on December 28th. We're going to see what happens with that regulatory action, but they may make the arm braces turn regular Title I firearms into Title II. And again, beyond the scope of this class. Rifle is a weapon designed or redesigned, made or remade, and intended to be fired from the shoulder. And it, again, they use the term explosive here. And there are some length restrictions on that. We'll talk more about that when we get to Title II. A shotgun is a weapon designed or redesigned and intended to be, again, fired from the shoulder, and that uses an explosive or combustion. There are actually some firearms that are produced that don't fall in any of these categories. The Mossberg Shockwave is a good example. It has a bird's head grip. So it's not a pistol, it's not a shotgun because it isn't intended to be fired from the shoulder, but it's also not intended to be fired from one-handed. And so those end up just getting categorized as a general term of firearm. Now, as you begin working on estates and you have people that are going to be beneficiaries, recipients of items, and Jamie's going to talk about this in greater detail, but you need to understand that people can't receive firearms if, in fact, they are a prohibited person. And let's just go very quickly through what the prohibited persons list entails. Number one is under indictment for or has been convicted of a crime punishable by imprisonment for a term exceeding 1 year. Now, right here's one of the practice tips I want to point out to people who don't play in the firearms world very often. This doesn't say convicted of a felony. It is any offense punishable by imprisonment for a term exceeding 1 year. Now, that seems to be a pretty easy thing to interpret right up until you realize that we've redefined the phrase 1 year to also include common law misdemeanors under state law that have a possible sentence which exceeds 2 years, regardless of the actual sentence imposed. And here are the states you need to look out for. If someone has a common law misdemeanor offense from Maryland, South Carolina, New Jersey, Pennsylvania, or Massachusetts, you need to do a little more research and find out whether or not their misdemeanor is actually one of these older common law misdemeanors that would have a potential sentence of greater than 2 years. Even if no one is ever sentenced that far, if it has that potential, that's going to put them in the NICS system as a prohibited person. You're also prohibited if you're a fugitive from justice, and that includes anyone that has any kind of open warrant, even some basic warrants. They are a prohibited person. If they are an unlawful user or addicted to a controlled substance as defined in the Controlled Substance Act. And here's another important practice tips. This includes those using medical marijuana or recreational marijuana under the laws of any state that have legalized that. So make sure that your clients are aware of the fact that until the feds ultimately, I believe they will, decriminalize marijuana, they are prohibited under federal law, even if they are complying with state law. Now, the other part of this that always confuses people is we're also not necessarily looking for convictions here. The way the NICS system works whenever someone is checked for a prohibitor is they're looking for banners or flags. And if you are charged with a drug offense within the last 365 days, even if you were found not guilty, you have a banner in NICS showing that you are presumptively an illegal user. And that is a rebuttable presumption, but it requires a NICS appeal. So keep that in mind. Other people who are prohibited are those who have been adjudicated as a mental defective or have been committed to any mental institution. Truly voluntary admissions are not a prohibitor under federal law. But for example, here in Virginia, we have a fairly complex law that confuses a lot of people that prohibits certain voluntary treatment as well. We'll talk more about that in a bit. Other prohibitors are an alien who is illegally or unlawfully in the United States, a non-immigrant alien who does not meet one of the federal exceptions. And another practice tip, green card holders are treated exactly the same as U.S. citizens for firearms purposes. Now, as far as non-immigrant aliens are concerned, there are a number of exceptions. The one that everyone uses is a hunting license. Make sure when you're advising clients or beneficiaries that you let them know that if they are here on a non-immigrant visa, they need to get a non-resident hunting license from the state where this was, where they are taking advantage of the exception. We had a case out of Arizona where some students who were here from China actually had an Arizona hunting license, but they had a resident hunting license, which it was determined they weren't eligible for. Therefore, they didn't have a valid hunting license. Therefore, they were prohibited possessors. It ultimately ended up in their deportation. So be very careful about that. Anyone who has been discharged from the armed forces under dishonorable conditions. Note that this does not say other than honorable, it says dishonorable. Anyone who has renounced their citizenship. Here's one that I run into with a lot of people as well. You'll get expats who renounce their citizenship, move overseas. They come back to the U.S. at some point in the future. They get renaturalized. Those persons are not able to get their gun rights back if they are renaturalized, because once you renounce your citizenship, it is a permanent loss of gun rights. If you are subject to a court order that restrains you from harassing, stalking, threatening, so each state can codify these a little bit differently, but protective or restraining orders, it does require that it be issued with due process, meaning an ex parte order would not kick in the federal prohibitor. Most states also have some laws governing how ex parte emergency orders are handled, and you'll want to familiarize yourself with that. And if they have been convicted in any court of a misdemeanor crime of domestic violence, and this was the definition of the elements that have to be met, the relationship between the parties, etc., already has a great deal of case law. And that was confounded by some additional law that was passed earlier this year that included, they called it the boyfriend loophole. It included people that you had even dated within a reasonable period of time. And of course, we really don't have case law yet to define what that reasonable period of time is. So we're going to see a number of cases where people get swept up probably into too broad of a sweep with that, but that is something you need to be aware of. In addition to the we talked earlier, in addition to the federal prohibitions about those who have been committed, many states have their own prohibitions on voluntary treatment and how you got there. Virginia, for example, if you were taken in by law enforcement on what we call a temporary detention order, and then you subsequently are allowed to leave because you agree to attend mandatory outpatient treatment, that still strips you of your gun rights. And so that is something that you'll want to be aware of, is whatever state you're practicing in and whatever state that your beneficiaries might be in, you need to be aware of whether or not the people that the estate's going to be handling firearms to are in fact prohibited. There's some additional prohibitions that Virginia has, that there's some analogs under federal law as well. And we also had some recent legislation that was passed to make sure that juvenile convictions in states that don't adjudicate juveniles, but in fact convict them, were also counted as prohibitors. In Virginia, we adjudicate juveniles as delinquent rather than convict them. However, the way we handle that is, if you get adjudicated delinquent of a crime as a juvenile for an offense that would have been a felony if committed by an adult, and you do that, then you lose your gun rights until you turn 29, at which point it's an automatic restoration. But there are 4 offenses that it's a lifetime prohibition unless you are restored by the courts, and that would be robbery with the presentation of a firearm, rape, murder, and kidnapping. And that's a lifetime prohibition even for a juvenile adjudication. And again, we do have a restoration process in Virginia that people can petition. It's a discretionary process, but it is something that those with a lifetime prohibition can potentially avail themselves of. And of course, anyone who is subject to a protective order. We also have a 5-year prohibition on the purchase of handguns if you have 2 or more misdemeanor convictions of possession of a controlled substance within a 36-month period. Again, with some of our changes to our marijuana and drug laws here in Virginia, this may be a law that has seen its time, because some of the harder drugs, they tend to always charge at the felony level. We'll see what happens with this in the upcoming years. I do make a note here. And again, these are the kind of weeds that you can get into when you start looking at the melding of state and federal law on these prohibitors. Virginia's ban is automatically lifted when 5 years have passed following the last conviction. But if there has been no intervening additional charge, if there has, the code isn't really clear on what would happen then. And so we're assuming that it resets the clock and it's 5 years after the third of those convictions. But not all of these prohibitor statutes are properly drafted. Now, Virginia also imposes a prohibition on any person who is subject to a substantial risk order entered by Virginia or any other state. I'm certain many of you have heard over the last few years, there's been a great deal of media attention to so-called red flag laws. Again, in Virginia, we have a very robust system. We have both temporary detention orders and emergency custody orders that allow us to deal with the type of situations that these red flag laws were supposedly designed to handle. So Virginia did in fact pass one, but in my practice, and I spend a great deal of my time in the firearms world, I have seen maybe one use of the red flag law. Everyone in law enforcement continues to use the TDO and ECO framework when they need to bring people into the mental health system and get them help. There was a lot of discussion about these laws, about the fact that they would subject law-abiding citizens to overreach by allowing persons to inappropriately report them into the red flag system. And I think some of the laws that have passed throughout the country probably are subject to that type of misuse. Virginia's has a decent amount of due process protection, and so I think really it's going to just end up being a statute that's almost never used here. Now, we also have, in what I would categorize as possibly one of the less useful statutes that we've passed in recent years, it has a voluntary do not sell list in which you can ask to have yourself included. And if you ask to have yourself included on this, then you will be denied anytime you try and purchase a firearm. And if you request that you be removed from this list, you have to wait 21 days before that request can be granted. Again, we have some similar ones as far as non-immigrant aliens. Let's just jump right in here. We've also have the Bruen case, the recent Supreme Court case, New York State Rifle and Pistol versus Bruen. It has been a sea change where gun rights are concerned. It builds on Heller, and it makes it clear that the Second Amendment is not a second-class right, that it protects all firearms in common use. I should note that the most common firearm in use today and for many years has been the AR-15 style sporting rifles. So a lot of states' attempts to ban these commonly owned items, I believe, will ultimately fail under the Bruen ruling. And it does continue to allow regulation, but it rejects the interest balancing test and imposes a standard requiring historical precedence. So we've got literally over a decade of litigation in front of us before we see where all the states end up landing after all this. Then, by the way, Virginia recently also adopted a universal background check requirement. This went into effect in 2020. It requires that when any firearm is transferred subject to a sale, a trade, or any transfer for which consideration other than love was given, that you have to undergo the background check at a dealer in order for that transfer to take place, as opposed to private sales, which were the law of the land up until that point. Now, because of that, and because dealers legally can't transfer handguns to those under the age of 21, those between the ages of 18 and 21 who had previously in Virginia been allowed to own, to purchase handguns in private sales, were denied the ability to own those. And we do have an injunction that was issued by Judge Yates in the Lynchburg Circuit Court that remains in effect, that enjoins enforcement of this law against those 18 to 20 years old who are seeking to buy handguns. So they can still buy those in truly private sales as of this point. We also have a limit on multiple handgun purchases here in Virginia. I know some other states do as well. There's a number of exemptions. I have them listed here. I don't want to cut into Jamie's time, so I'm not going to go into any great detail. But having a concealed handgun permit exempts you from that, and you can also ask the state police to grant it for specific reasons. Now, all of that is Title I firearms and the prohibitors that we have there. Most of the prohibitors carry directly over to Title II, but the process is very different. And I'm just going to briefly talk about what things you'll run into in the Title II. And here is a list of acronyms that you need to be aware of just to start the conversation. I'm not going to read all of them to you, but I will say NFA means National Firearms Act. SBR means short-barreled rifle. SBS is a short-barrel shotgun. AOW is any other weapon other than a handgun that is concealable. CLEO means Chief Law Enforcement Officer. And the NFRTR is the database that the ATF maintains with the registry of all the NFA items. If you ever find yourself doing a criminal case involving whether or not an NFA item is properly registered, you should do some research on some of the cases that have came before as to how accurate the NFRTR is. There's some interesting case law and expert testimony on that you'll want to look at. Anyway, Here is the ultimate goal when you're dealing with Title II. You need to be issued a tax stamp. This is an excise tax stamp. Most of them cost $200. There's one case where an AOW that's being subsequently transferred only costs $5, but generally all NFA items, the tax stamp you're getting costs $200. It looks like this. And that's the ultimate goal when you're filling out the paperwork to get your Title II firearm. I have here a history of the NFA, which I'm not going to go into at this point, again, because there's a lot of material here, but it started off being handled by the IRS. And again, the payment of the excise tax is still a tax payment. But it has since been formed, and it has been moved over to the Department of Justice. And that, I was just looking here, that happened in 2003 as a result of the Homeland Security Bill. And so that's where it is now. But the excise tax is still a tax payment, and the tax privacy provisions still apply. So when, for example, I'm doing an ATF hearing for a client coming up, and you still have to certify certain things, just like you were practicing before the IRS, in order to discuss their tax payments. Okay, so very quickly, the type of items that are going to be in the NFA, you're going to have suppressors. You'll hear them called silencers all the time in movies, etc. Movies present them very inaccurately. They will reduce the sound of the report by a number of decibels, so it kind of comes down from will damage your eardrums on one event if unprotected to about the volume of a jackhammer. And a short-barreled rifle is a rifle with a barrel of less than 16 inches, or it has an overall length of less than 26 inches. And again, there's some discussion here of the arm braces and adding butt stocks, as well as there's quite a bit of constructive possession case law that you should read about. Short barrel shotgun, again, it's a regular shotgun that has had a barrel down to less than 18 inches or an overall length of less than 26 inches. An AOW is a concealable item that is not a handgun, but is still deemed to be concealable. And these are largely AOWs because the ATF says they're AOWs. It is a very, very mushy definition. You want to look into that if you think anything falls into that category. Obviously, machine guns are firearms that fire more than once with a single pull of the trigger. There's been a lot of rather ridiculous rulings from the ATF down through the years because of the way this is interpreted. The butt stock or the bump stock ban that came about 2 years ago, which is clearly not a machine gun under any common reading of the definition, but was stretched into it. And we recently had the forced reset triggers that were declared to be machine guns, and a lot of us in the firearms world are helping clients surrender those, etc. right now. So a lot of definitional stuff there. And then destructive devices. This is the one that even those of us that are deep into the firearms world don't run into a lot. Sometimes I have had the occasional estate where my executor will call me up and tell me that I opened the gun safe and there appears to be a grenade sitting on the top of the gun safe. And we've actually had to call out the bomb squad on a number of occasions because we couldn't find a tax stamp. We didn't know whether it was a dummy or whether it was, an actual live grenade. And so you may occasionally run into those. And there's some other more exotic items. You'll definitely know if you run into a destructive device, though. All right. Now, unlike regular firearms, which can't be registered under federal law, these have to be registered. And they have to be, there are forms that you have to fill out. And then there's additional state issues that have to be satisfied as well. I'm not going to go into those, but here this is going to lead into some of the subsequent material that we're going to cover, which is there are multiple methods of ownership. And that multiple method of ownership is individual or trust. And let me see here. I'm going to look at where we are in the, and so as the next few slides down through here are going to be some slides where we talk about the actual registration process and all of that. Looking at our time here, though, I've moved us ahead to where we're going to start with Jamie and let her cover her material. We will come back and cover any questions that you have about that, though, when we get to the end, if we have time remaining. So, Jamie?
Thank you, John, and good afternoon to everyone. As John stated, it is a privilege to be here, and I'm honored to be able to talk to you today about estate administration of firearms. As you can see from hearing from John, he is probably a lot deeper into it than I am. My office handles estate planning and probate, but we deal with a lot of firearms when it comes to the probate part of things. So that is what I am charged with talking to you about today. Where does the probate fit in when you have a client who has now discovered that this estate involves a lot of firearms? You have to first be cautious, because even though there may not be state laws governing the transactions or what happens during this process, there will be federal laws that govern what happens during this process. So not only does your client need to know about the state laws, they also need to be aware of the federal laws, because if you're dealing with a Title I or Title II firearm, then you need to know and be able to counsel your client on how they need to deal with that. So the things that we're going to talk about are some of the critical conditions or considerations when you have someone who's come to you, they need to probate, and they have now discovered that the person, the decedent, owns all of these firearms. What do you need to tell them to do? There are a couple things that you need to first tell them to take into consideration before going further, and those are the things we're going to talk about. First, we'll talk about how they need to store the firearms, what information they need to gather. Then we'll go into evaluation and looking at whether or not they qualify. John has already talked to you all some about the qualifying beneficiaries and how that plays, so we won't spend a lot of time on that, but we still need to go over it, because as I stated, even if the state law doesn't apply, like in Georgia, they don't necessarily have any rules about transferring firearms. Other states do, so you need to be aware of those in your particular state. So person A has come to you, they say, okay, this person's passed and I need to probate their estate, but I discovered all these firearms and I don't know what to do with them. Well, the first thing you need to tell them is they need to gather the firearms and make sure they're properly storing them. Later on, we'll talk about what will happen if you don't properly handle firearms and what that can mean for the executor. So they need to make sure that they're actually storing these firearms properly. In some situations, not properly storing the firearms can even be considered a violation. So if you don't know how to tell them where they need to keep them, they need to research it or reach out to somebody else who can tell them how to store these guns. They'll also need to do an inventory. So tell them, take possession and safely store all firearm related items. The estate has a duty of care to properly safeguard all estate assets, and this includes guns. Identify the type of weapons. As you've heard John say, there's a difference between the Title I and Title II. Are these non-standard items? Are they ordinary guns or firearms? Are they suppressors? Are they fully automatic firearms, machine guns, short barrel rifles? What are they dealing with exactly? And then they'll need to classify them. A best practice is if you have it, you need to provide them with a list so that they can identify the different types of firearms, even if you have pictures, so that they can look at the pictures and try to identify them and figure out if they're dealing with a Title I or Title II firearm, because that's going to be important. Now, states don't have a gun registry. I have clients always ask me, well, how do I know which guns they have besides the ones that I see? I don't have the answer to that. In Georgia, they don't register the guns anywhere. So there are only 6 states where they register them. So the only thing they can really do is look around and try to find them in the house or wherever they think the person may keep those guns. Now, once they've gotten all the firearms together, the next important step with probate is to make sure that they gather any documents that they can. This truly is, just going through the paperwork, looking through their house, looking to see if they have those tax stamps that John mentioned, if we're dealing with Title II firearms, looking to see if they see anything that will give them any idea of how much a person paid for the weapon or the firearm. And I use weapon, guns. I don't actually use the word firearms like I should. I usually just say guns. So forgive me if I keep saying guns versus saying firearms, but I'm used to just calling them guns. So make sure that they have look to see if they see a bill of sale, receipts, registrations, titles, pictures. Sometimes you might even find a gun trust if they have that. Anything that they can help that will help them identify either how much the person paid for the gun or in some situations even what type of gun it is. Then they will want to make sure they prepare an inventory, and that's including a list of all of the a list of each gun that they have been able to identify, because that's going to be important in an valuation. The valuation is that's going to vary depending on where you are, the type of gun it is. It can vary based on the condition of the gun, the rarity, the nature of the modifications that have been made to them. Therefore, looking up what appears to be a similar gun on a website may provide a significantly inaccurate estimate of the gun's value. I tell my clients they should not attempt to determine the value of the gun themselves. Sorry. So in looking at the valuation, what are some of the things that you're going to look at? There are 3 likely categories that you're looking at when you're looking at the different firearms. 1, you're looking to see if it's a newer and or good quality firearm. Secondly, if it's an older firearm with limited utility, those are probably going to be worth a little less, even if it's functional. Generally, they don't really have any monetary value. They're just sentimental in value. And finally, if it's a very old firearm, because this may be considered an antique and worth something of significant value. The reason why this is important is because when you're presenting it to whomever is going to do the valuation, these are the things that they're going to look at. Well, who can you give this to if your client doesn't know how to evaluate? You need to value the gun, then you need to make sure they either consult with a firearm expert, a reputable pawn shop, gun stores. There are a couple websites like gunbroker.com where they can look. Reddit, that's another good site where they can at least narrow down the type of gun. And of course, some estate sale coordinators can also provide information on the value of the gun. Now, when they're conducting that inventory, one of the things that you want to make sure that you tell them to include, and I actually have a list that I provide to my clients as best practices when they're doing the inventory, is a form that I have them complete so that they can provide this information to the evaluator on the gun. That list includes what type of gun it is, if they know, or something basic like, is it a rifle? Is it a shotgun? Is it a handgun? Who the manufacturer is, the model, the caliber, the year it was manufactured, and any other significant features that may help help in the valuation of the gun. Now, once you have already determined the guns are properly stored, you've found any documents, your client has found any documents they have related to the guns, and you've got an evaluation, the next important step is to determine exactly whether or not they can possess the guns. Now, John has already gone over in good detail about who cannot possess a gun. And so, how do you determine whether or not they qualify to possess the gun outside of you just saying, hey, can you do you qualify? Well, as an executor, remember um, uh, you are charged with properly administering this estate. You're also charged with knowing the laws in your state. So if you're not familiar with the laws, you need to make sure that your client is consulting with someone who is familiar with the laws, especially when we're dealing with Title II firearms, because they can get in a lot of trouble if they don't comply with the requirements and if they transfer the guns to someone who isn't supposed to handle them. There are many different types of transfers that can occur, so they may do a in-state transfer where there aren't as many regulations versus an out-of-state transfer when you're dealing with Title II, and they could get in trouble for that. And you heard John talk about those in-state versus out-of-state transfers some. So you want to advise whoever is serving as the executor is that they first need to make sure that the person can receive the firearm. Two, the executor needs to make sure that they can possess the firearms, because what happens if they cannot possess it? That actually comes up even with some of my clients. Sometimes they say, well, because there aren't any qualifications necessarily to be executor. If I have a will, I can name whoever I want. But that doesn't mean that they actually have the ability to possess a firearm. So if they cannot legally, the executor cannot legally possess that firearm, then what they need to do is they're going to most likely have to either have somebody else named as the executor or administrator over the estate, because they can't at that point administer the estate, or they'll have to bring in a co-administrator to handle that particular part of the issue. If your client finds themselves in a situation where they cannot transfer the firearm to someone because they don't qualify, then what happens with that firearm? In that situation, then what they're going to do is look to, if there's a will, they'll need to look back at the will to see what it says. Does it revert back to the estate? Or if it doesn't speak to it, then they'll have to go to see what the law says about that. In other words, if it was an intestate situation, but most likely it's going to revert back to the estate. They may have to sell the firearm and then give that beneficiary the proceeds from the sale. Okay, and we've talked about the potential issues. It's a little hard for me to see these slides, so I'm also rolling through on my other screen. So what happens if you mistakenly or you transfer a firearm to someone who should not have received it? When administering an estate containing firearms, you have to consider the laws where the guns are located and where the beneficiary lives. You will also need to consider federal laws such as the NFA, National Firearms Act. The NFA regulates the registration and ownership of Class 3 weapons. The Class 3 firearms cannot be transferred without the approval and involvement of the Bureau of Alcohol, Tobacco, Firearms, and Explosives. Those in possession of a Class 3 firearm without the BATFE approval will face federal fines up to $250,000 and imprisonment as long as 10 years. So it's very important when your client is handling these firearms and transferring them, even if the will says it, that they make sure that whomever they're transferring it to qualifies. Not only do they have to take that into consideration when it comes to these Title II weapons and transferring, but they also have to look at it when it comes to in-state and out-of-state, because they could face serious criminal consequences for non-compliance. And if you recall, I talked about storing the weapons because some states even have penalties for not properly storing the weapons. the best thing you can do is to tell your client to make sure they're familiar with 18 USC 922. You can even give them a copy of it so they can review it and make sure that before they're doing any of these transfers that they aren't violating any of these regulations. Ultimately, when in doubt and no one wants the firearm, what should you do? Then in that case, you should consider just giving it to the local police department, or if you're going to sell it and give the money to the person who you think would otherwise not qualify to receive the firearm. And I'm not sure if this question is for me or not, but I see a question from someone that says, is there any federal procedure to rehabilitate those who had their gun rights taken away? So I'll talk about that briefly. I'll let John chime in a little bit on that question, but you have to caution, because even if there's a federal, you still have to look and see what the state says as well. So the state may say, I think John said in Virginia, they have rehabilitation where the person at some point could qualify to receive the weapon. I'm not sure how that would, what role the federal play a part in. John?
Yeah, so that's actually an interesting question. I do a lot of gun rights restoration here in Virginia since it's available. And one of the very first questions that I always ask is, do you have a misdemeanor crime of domestic violence? Because that is a federal prohibitor. Up until last year, it wasn't a state prohibitor. So because at the federal level, it's a prohibitor, but at the state level, it was not. If you had one of those, and the state therefore never took away your rights, we have case law in the federal courts that says the states can't give them back, because it would be a definitional impossibility to give them back if they never took them. So in those cases, the only thing you can do is get a governor's pardon for that. Then I move on down, and the next question is, do you have any federal felonies? Because if you have a federal felony, it was the federal government that took away your rights, not the states. And again, the states can't restore them. So that goes to the heart of your question. Is there a federal procedure to rehabilitate those that had their rights taken away? And the answer is yes, there is a procedure. It was implemented back in the early 90s, I believe. And the very first year that procedure was available, the spending bill was modified to defund the program. And every year since then, the spending bill has been modified to defund that program. Very famously, those of you who are maybe a little bit closer to my age will remember that after he got out of prison, G. Gordon Liddy had a radio show, and he very famously offered to spend several $1 million of his own money to fund that office long enough for them to process his application. And the courts ruled that he did not have a right to do that. So yes, there is a process. It is not available to anyone. And so if someone has a federal felony or a federal prohibitor that is not matched by state law, there's nothing they can do other than a presidential pardon.
Okay, and then another question concerning the valuation. Someone wanted to know, do you have any recommendations for finding a licensed firearms dealer for both Title I and Title II firearms? So if you go to gunbroker.com, that may be helpful. You can check with pawn shops. Many times they can assist with finding a licensed firearm dealer to deal with both Title I and Title II firearms, and storage recommendations. So like I said, that's very important, because if they are not properly storing the guns, then they can actually possibly be considered to breach their responsibility as the executor of the estate. So you don't want them to store them like in a damp place. A gun safe is always a great place to tell them to store the gun. When in doubt, they can go and purchase one that can be charged to the estate. So that would be my recommendation for storing the guns, is to put them in a safe for many reasons. One, to prevent people from stealing them. Two, to keep them safe. And 3, you know that that's a proper place for storage. So you can tell the client that they should go ahead and purchase one, keep them in that place, make sure they have the inventory. And also, I recommend that my clients take pictures of all the guns that they recover.
Jamie, if I can just interject, I posted in the public chat a link to the ATF website where you can search for firearms dealers by state and download a complete list of currently licensed people. So that's another resource people can use.
All right. So now we will move on to how do you actually prevent this? What can we do so that you don't have to come to Jamie and say, we have all these guns and we don't know what to do with them? Well, one of the things that you can do is to do a gun trust. That is a surefire way to avoid many of the issues that we've talked about today. Not only does it avoid probate, but it allows the person who owns the gun to transfer the guns to whomever they want them to go to, depending on if they do a revocable or irrevocable death, but I mean a trust, but let's just say they're doing a revocable trust. So at the time of their death or however they've outlined in the trust for that transfer to occur, it also allows them to give detailed information to the executor about the transfer requirements. And this is important because many times you may be dealing with executors who might not know a lot about guns or might not know a lot about the type of guns that this person has or the value of those guns. It may even lend some information to the executor about the value of the guns. So it's very important, if you can, to talk to your clients who are gun lovers, or a lot of them have some antique guns, to talk to them about possibly doing a gun trust so that they'll avoid these issues, or their loved ones will avoid these issues when it comes time to probate their estate. And one of the big reasons why I recommend a gun trust is because a lot of people do want to transfer their guns to minors, and they may want to give them to their grandchildren. And so a gun trust is a great way for them to do that and to make sure that that gun is held in trust by someone until that minor child can reach the age where they can receive it. And sometimes it might not be 18. They might not want them to receive it at the age of 18, especially when we're dealing with particularly valuable firearms. They may want them to receive it at a later date. So a gun trust is a good way to make sure that it stays in trust until not until they think the person is responsible enough to receive it, but to appreciate the value of that. So that you're not giving a firearm to someone at the age of 21 and they go and sell it. So you might want to wait until this allows them to wait until the person is of an age where they think that they can appreciate the value of what they're receiving. Now, in most cases, when you're talking about a gun trust, you're talking about Title II guns. However, they can be used for ordinary guns as well. John is going to talk mostly about the Title II part of the gun trust. As I said, most of the Title I provisions, most Title I guns are people don't necessarily do a gun trust for, but they should. So some of the drafting considerations when you're drafting these gun trusts, you need to be very specific. The same way I outlined some of the things that your executor will need to do when they're preparing that inventory, those are the same things that need to happen when you're preparing the gun trust. It needs to be very specific. We need serial numbers. We need the color, make, and model. If there are any accessories to the gun, you need to also describe those, be very specific so that when your trustee has to distribute this firearm, they know exactly which weapon you're referring to. If you can, you also need to categorize the firearm so that they'll know if it's a Title I or Title II firearm, because like I said, sometimes whoever you're naming as trustee may not be as familiar as the grantor is with this. So you need to make sure that you're very specific in talking about if this is a Title I or Title II weapon, so that you're providing that information to whomever is going to serve as the trustee. Also, if you recall, I mentioned what happens when we're dealing with probate. What happens if the person doesn't qualify? Well, if you have a trust, you can actually address that in the trust. So if it comes out that the person that they wanted to transfer that weapon to no longer is eligible to receive it. So at first, when they were living, then this person may have been living the model life, but by the time they're gone, something has happened and they've found themselves a felon and they can no longer possess this firearm. Then the gun trust allows you to address those issues so that you don't have an executor out there wondering what they're supposed to do with the weapon at this time. And finally, one of the things that you consider are the NFA considerations. And with that, I'm going to turn it back over to John. You're on mute.
Thank you for catching that for me. And thank you for that material. A couple things I'll follow up on some of the great material that Jamie had there is, if you do find yourself assisting clients in valuing firearms, or they're simply asking you for more resources, there is a book that's put out every year called the Blue Book of Gun Values. It's a very large book. You can search specific manufacturer, model, and year combinations, and it does give relative values. And if you ever find yourself advising an executor of a large collection, there are companies that auction companies that will come in and auction off the entire collection. One of the ones that I use as a resource all the time, because you can see what a particular firearm went for at the last auction, is Rock Island Auction. Just for example, there are others, but that's one that I use a lot. And I know Jamie had mentioned one thing about the executor potentially not being able to even handle firearms, and how do you handle that? I always make sure when I draft wills that I throw in a clause in the drafted will allowing the executor the power to appoint themselves a co-executor if they need to for any legal reason. And that is exactly the kind of situation that I'm talking about there. And then just to clear off the last of the questions here before I jump into the next part, we have a question here. Who is typically storing guns in anticipating the minor person reaching the magic age? When we draft these trusts, we name successor trustees, and I usually stack them. There's a primary, a secondary, a tertiary. So if my client William dies and he wants to leave everything to his 6-year-old son Jared, I say, okay, if you die tomorrow, who's going to hold these items until Jared is old enough to get them? And they'll say, my brother Joe. Okay, what if you and Joe get hit by lightning together? Who's the backup to Joe? And I'll stack 2 or 3 of those there so that you've got successor trustees, because if you ever get into a situation where they have to appoint a successor trustee, the value is going to go down. And I think Jamie had an add-on.
Yeah, I was going to chime in there because, of course, in all situations, we don't have a trust. So even in the will, that's addressed. Usually in the will, it says that the executor can also serve as trustee in the event they have to hold something until someone becomes eligible. So even if your client doesn't have a trust, that should be covered in the will. And if there isn't a will or a trust, then most likely they're going to have someone appointed to hold that. In Georgia, I can tell you, you have to, whenever we're transferring or something is bequeathed to a minor, then that someone has to be appointed as guardian or conservator for the minor. So in the event there's no trust or there isn't a will, then someone would have to be appointed as the conservator or guardian so that they can hold that item in trust until the minor reach the age where they can receive it.
And I think a lot of states, including Virginia, has some form of the Universal Transfer to Minors Act, which would govern items that go to whoever is appointed guardian of a child when there is no other provisions. I will add, by the way, that if the person owns Title II items, not in a trust, but it has to go through their regular estate. The estate has to remain open until all those Title II items are addressed, which loses the ability to take advantage of expedited probate, and it causes the estate to remain open so more creditors might file claims. There's a lot of reasons why we want to have Title II items in trust, and we're going to talk about that in a minute. One more question. Oh, it does? One more question. Is there a specific statute governing gun trusts? Of course, trusts are a creature of state law. And so I can't state that there's not a state that doesn't have some statutes that might have some specific provisions. But in Virginia and every state that I'm familiar with, it's simply a trust. And then you have to put in the necessary provisions to handle the Title I and Title II type issues.
Yes, we're calling them gun trusts, but it's just basically a revocable or irrevocable trust with language about guns.
Exactly. That's really what it is. And that's why it's so important that when we draft these, that we have the appropriate language in there so that the successor trustee, who might not be any more familiar than the executor of the will, knows exactly what they can do and what they have to do. So jumping right into using these trusts for NFA items, these are some of the benefits that Jamie already spoke about. But, again, the detailed guidance to those familiar with the NFA. And then the last one here, greatly expanded usability. That's really one of the two keys as to why no one should ever own an NFA item individually. And let's say, for example, that Jamie has a dove hunting shotgun, and a friend of hers comes to her and says, I'm going to go to Montana on a dove hunting trip and mine broke. Can I borrow yours? And they want to go to Montana for 3 months on this trip and then come back with a regular, old, ordinary shotgun. That would not be a problem in Virginia. I'm not licensed in Georgia. I don't believe that would be a problem in Georgia either, because you're simply loaning it to a friend or family member who is not a prohibited person. They're going to transport it legally, go on a hunt, and come back. With an NFA item, because of the way the transfer regulations that have been promulgated subject to the NFA are concerned, with a clear language reading of the statute and the regulations, if you own it individually, except for a licensed gunsmith who is working on it, you're the only human being that should touch it until you die. That means you're at the range and your son, your daughter, your brother, your spouse, your parent says, hey, can I shoot that? The legal answer is no, you cannot, because I own this individually. That's where a trust comes in. A trust allows you to do two things. Number one is a corporate ownership. If you've got appropriate language in your trust, you can set it up so that anyone that you share it with in a sporting capacity is deemed to be a temporary non-equity beneficiary so that they can have some access. And then number two is you can actually name other responsible persons on the trust, and those people could then take it, and once they got the appropriate permission to transport it across state lines, because you have to do that with Title II firearms, they could take it on a hunt out of state, stay there 3 weeks, and come back without you being with them. So it drastically expands the usability of these much more heavily regulated items. Now, drafting considerations when you're talking about NFA-specific trust, revocable or irrevocable. And again, this is the same question that you would ask in a regular trust. The answer is almost always revocable. There's some very specific reasons that we do irrevocable trusts, and they're very rare, at least in my experience. And so I think most of the ones you're going to encounter are going to be standard revocable trust right up until the settlor passes, at which point it becomes irrevocable and begins distribution, or at least begins holding for a minor. Are we doing a trust that is measured by the life of the settlor? Do they want to try and do multi-generational or even perpetual? I get a lot of people who call me up and talk about doing a perpetual trust for a single suppressor. And I very gently talk them out of that and explain to them, the problems that are going to arise with trying to do a perpetual trust with a single suppressor. But you want to talk to them about their goals and what they really want to do, and then explain to them the reason we want to transfer it upon the end of the settler's life usually is so their beneficiaries can then bring in their friends and family and their children and keep it going and have the controls. Key provisions. Jamie had talked about what happens if someone attached to the trust becomes prohibited. You want to have a clause in there that treats the settlor as deceased or allows their full separation if they become a prohibited person. You want to have the same thing that removes a trustee if they become a prohibited person. You want to have something in there that treats the beneficiary as having predeceased the settlor if they become a prohibited person. You need to let the successor trustee know what they need to do when the settlor passes, because they might not be familiar with this whole process. In fact, they're almost never familiar with it. You want to put some guidance in there, making sure that they don't inadvertently allow the items to cross state lines without getting Form 20 approval. You want to make sure they understand how a lot of the clauses that I put in my NFA trusts are as much informational as they are legal. You want them to know what happened. How do I go about handling a permanent relocation of the items across state lines? I always make sure that I make it clear that copies of the trust are to be treated as original if they're held forward as original by the settlor or trustee. Now, back in 2016, it actually went into effect on July 13th, a rule called 41F. Prior to that date, if you bought your NFA items using a trust as opposed to individually, you didn't have to get fingerprinted. You didn't have to submit photographs. You didn't have to get the chief law enforcement officer in your jurisdiction to sign off on it, all of which were things that individual applicants had to do. And so what that led to was the CLEOs in various counties were either not signing these forms, they refused to, or they would only sign them for people who had donated to their election campaign, or it became quite the mess. And so everyone moved over and started buying these with trust because the statute said, individuals had to do these things. So 41F was a rule that was promulgated between 2013, went into effect in 2016, and it changed how all of this happened. So first of all, it did away with the chief law enforcement officer having to sign anything in order for you to get an NFA item. They have to be notified, but they have no provision to deny it anymore. So many law enforcement agencies I'm aware of literally get them in, look at it, realize it's a CLEO notification for a Title II item, and discard it because they no longer have to run the background of the person or do any sort of approval. That's now all done at the FBI. But because of that, now the settlor and any other responsible trustee on the trust has to be fingerprinted, photographed, and submit what's called a Form 23, which is basically a background check form. And it also moved it from the state point of contacts up to the FBI. So on July 13, 2016, the FBI woke up one day and suddenly had hundreds of thousands of additional background checks that they had to do every year with no additional funding or manpower. And we've had a lot of wait times since then. But nonetheless, that's the change that happened with 41F. So now, one of the things that happened is when we're talking, we used to have people, when they were making trust, we'd have them put their spouse, their adult children, their third cousin twice removed, and their neighbor Carl, all as joint trustees, just in case they ever wanted to have unattended access to the items. Now that all responsible persons have to undergo that process, we become much more careful about selecting responsible persons for the trust. And let me move these slides forward a little bit. I've kind of talked ahead of myself here. So that last slide actually had a point that we should talk about briefly. The way I draft my trusts, successor trustees only take power when the settlor dies, and beneficiaries do not have any ability to compel the trustee during the settlor's life. Therefore, neither of those are responsible persons under the definition. The only responsible persons are the settlor and any joint or current trustees on the trust. And you want to make sure you draft yours that way. You know, I talk a little bit more about here, when you lay out the powers and duties, you got to make sure that you are limiting and or granting the appropriate level of power. I noted there that there is some discussion inside the ATF regarding whether or not beneficiaries who can't compel but can ask for lifetime, access during their life, not unattended access, but just access, are considered responsible persons. I personally, I actually remember exactly when. It was between Christmas and New Year of 2018, because I had to do a lot of amendments. But I changed the language in my trust to make it clear that they were in fact not responsible persons. And you want, again, the first time you run one of your trusts through the ATF, and you're going to get feedback from them regarding anything that they think takes it outside the bounds of 41F. And they've been very cognizant of that ever since 41F was promulgated. And I see one more question here. What is the typical charge in your jurisdiction for preparing such a gun trust? So I'll tell you, it's all over my website. It's not a big secret. I do the majority of the gun trusts that come out of Virginia right now, and my trusts are a flat fee of $100, and that comes with lifetime free updates, changes, and questions. And that is not a typical fee for these type of trusts by any stretch.
$100?
Yes, I've kind of turned it into a bit of a commodity process here. In reality, most attorneys throughout the state that also do them, it's more in the $500 range for a gun trust. So a lot of it depends on the market there and who's doing it. So I am very much an outlier in that regard, and it's because of volume and technology and where I am in that industry here in Virginia. So that's not how I price my other.
Okay, I'll be very frank. My price is quite different than that. It starts at $1,500, but it always depends on, like John has said, it depends on the client's needs, what it is that they're trying to, what it is they're trying to achieve. But we start at $1,500. I also noticed another question down there, John, about. It said, do you suggest gun trusts for Title I firearms? Well, yes, I suggest them for Title I or Title II firearms. We just focused on Title II because of the implications involved in Title II firearms. But yes, you definitely need to also, if your client is so willing to do, get them to do one for Title Is as well, for the same reasons as Title II. Still, even if you're dealing with an ordinary firearm, there are still certain things that they may want to put into the trust, like what happens in the event that it's a minor, what happens in the event that you're dealing with a prohibited person, what happens in the event that the person can no longer take, or what you want to see happen with that firearm. Also, remember that the trust is not just telling them or giving them direction about what happens to the weapon at the death of the grantor, but it's also giving information about that firearm. So in that trust, you can list specifically what type of firearms, even if they are just limited to Title I firearms, you can list specifically the model, make, manufacturer, any specifications, values, things like that. So yes, I would encourage you to also do them for Title I and not just reserve it for Title II.
Absolutely. And I tend to focus so much on the NFA because that is the world that I live in pretty much every day because of what I do here. But Title I's, even though the benefits are reduced, I mean, the one that we always start with is avoidance of probate, right? And when all is said and done, most of us here today do estate work, and avoidance of probate is a very good thing by itself. And by having the firearms inventoried, as Jamie suggested, it really just makes when your clients leave their family behind having to deal with a large collection, if they've got it properly inventoried in a regular firearms trust, it's going to make things so much easier for their family. And that's the other goal that we want to help our clients with when doing estate planning, is to not leave their family a mess.
John, let me just ask you, because you mentioned something and I was curious about it. What happens in Virginia if you unknowingly transfer a firearm to someone who is prohibited? Do you know?
Well, when you say unknowingly, so again, prior to the universal background check law, when we had private transfers
yes,
here in
we
Virginia,
don't have that in Georgia. So we don't require a background. If it's person to person, private sale to private sale, you don't have to do a background check here in Georgia.
And that was the case here in Virginia up until just a couple years ago. And so during that time, if you did not know that a person was prohibited and you had no reason to know, you can't have intentional ignorance, right? But you had no reason to know, and the person held themselves forward as not being a prohibited person, there was no criminal liability. Now, obviously, you and I both know civil liability can occur from anything, depending on whether or not your actions could be deemed to be reckless. But criminally, you would not have been liable if you didn't know in a private transfer. One thing, actually, while we're talking, you had mentioned earlier about if the person just really doesn't want the firearms, that they can surrender them to local law enforcement. I'll just add one caveat to that. If there are any NFA items there, I would recommend, instead of local law enforcement, that you call your local RAC for the ATF, the resident agent in charge of your local field office, and arrange for them to come pick them up so that your client can get a proper surrender receipt, because that item is registered in the NFRTR and we don't want it to just disappear. You don't want it to somehow disappear from a local law enforcement evidence room and end up in someone's collection and maybe later on show up somewhere that it shouldn't, and your client has no way to prove that it was surrendered. So if there are any Title II firearms, I would recommend surrendering those to the ATF instead of local law enforcement.
And just to piggyback on that a little bit, in any event, you should always try to see if you can sell it first. I hate to say that, but because you're the executor, you do have a fiduciary responsibility to the beneficiaries. So what you need to do is first see if it has any value. So that valuation is important, because even if no one wants it, like they've left the firearm to someone who doesn't want it, you still need to make sure there's no value there, because they may be able to get compensation for that weapon. So before you give it to anybody or donate it to anywhere, you need to make sure there's no value there, because otherwise the estate may be able to go ahead and sell it, and then that money would go to whomever that beneficiary is.
And, you know, one of the questions that I'm often asked is, we'll have someone who died intestate, and the person who ultimately qualifies for the estate has no experience with firearms, and they're the ones that are going to be the beneficiary. And we've got these Title II items that we can't find the tax stamp for. So then they hire me, and then we reach out together. You have to be very careful because remember, these are tax records. So you have to follow all the IRS privacy provisions. But we reach out and see if the ATF can find the registration. If we believe we have, say, a machine gun or something that isn't properly registered in the NFRTR. I recently had one, a beautiful World War II machine gun that had been brought back as a war trophy by someone who had really an exemplary service in World War II. I won't say any more than that, but we couldn't find the tax stamp. And what we ultimately ended up doing was finding a armed services museum. So there are only state and federal museums that are owned by the state or the federal government can accept these as donations. Private museums cannot. But if you have an item that you can't prove is registered, which means you can't transfer it, you either have to destroy it, surrender it, or find a museum who will take it. And in that case, we were lucky enough to find a museum that would take it and tell it as part of the deceased story. But it's getting harder and harder to find museums that have room in their collection because people have been donating these for a long time now. And so unless it has a real unique story or is in better shape than anything that they have in their collection, you usually end up having to just surrender it. And again, destruction is an option, and you can demill these items. The ATF actually publishes a demilling guide that shows you where to make the cuts on different receivers, how much metal has to come out. And if you properly render it inoperable, and I say properly and underline that, because if you don't properly render it inoperable, then you're still in illegal possession. And so you want to make sure that you advise your client to do that correctly, but that is another option.
If I may interrupt at this point, first of all, I want to thank both you, John and Jamie, for your insights today. I do have a brief announcement. New York and Kansas states require that you record and report the following code to obtain CLE credits for the live or recorded version of this CLE webinar. If you will be requesting CLE credits for this seminar, please write this code down. The code is TLIDAI. That's T like Tango, L like Lima, I like India, D like Delta, A like Alpha, I like India. Again, that is TLIDAI. Now on to our live question and answer session. Listeners can ask our speakers any questions relevant to today's topic. You may email questions to estateplan@stratfordpub.com or submit questions by typing your question into the Q&A box at the right side of the screen and press enter. And with that, I will turn it back over to you, John and Jamie, to handle any other questions that may have come in.
Jamie, I know I tend to ramble on more than I should. Did you have any other questions that you had noted during the program that you wanted to bring up?
That's what I'm rolling through them right now. I tried to answer them sort of as we were going through the program. So I'm looking right now to see if I see any additional questions that were asked while we were going through it.
Well, I'll cover one. Oh, go ahead.
I would be curious to know, back to this cost thing, how you're getting away with charging $100 for a whole trust.
Well, and again, it kind of goes back to a practice management thing. I wasn't joking when I say I do the majority of all the NFA trusts that come out of Virginia. It's a it's a volume thing. It's a technology thing, and so it's the amount of time that I spend on it, the systems that I have in place to handle, all the hundreds of requests I get every day to update trustees, to update beneficiaries, to add items to the trust. I mean, it's very much systematized. And again, that's not in keeping with my fees for other legal services, which are not sort of commodity systematized services. Then you're getting back into the same range that yourself and I'm sure other practitioners do. It's just, this is sort of a niche that I have fallen into over the decade. And I end up here today doing, many trusts every day. And that's what we do.
And one of the ways you can generate more business as far as that's concerned is whenever you're doing, at least with me, whenever I'm dealing with a probate and we come across these firearm issues, is I provide the sheet that I refer to clients showing them how they should inventory the guns. And this helps not only during the probate process, but also in the future with business, and helps educate the executor who may or may not be educated with firearms, make sure they're properly inventorying their firearms during their lifetime, so that they're not just acquiring these firearms and not inventorying them, especially in states like Georgia where there is no registry, and most of the states, quite frankly, because I think it's only 6 that actually require it. So maybe one of the best practices, since we're still sort of talking about that, is to make sure that you're letting your clients know that if they can, to keep an inventory of whatever firearms they're in possession of. And that's not just the Title II firearms, but also the Title I firearms as well.
And I see we actually have a question that brings me back to a point that I meant to address earlier, and it fled my mind. So I'm very happy that this question came back up. The question is, in your experience, will a licensed firearm dealer offer storage services if a firearm cannot be held in a decedent's residence or the executor isn't comfortable holding it on his or her property? So first of all, for regular firearms, absolutely. Here's the thing you want to look out for there, though. I also represent a lot of dealers and manufacturers, and we have contracts, storage contracts. We've got one right now where the estate of firearms was placed there almost 3 years ago, and the storage fees at this point are getting close to exceeding the value of the collection because one of the beneficiaries challenged the will. And so it's been held up. And in the meantime, the estate is paying these storage fees. And we're probably within 3 months of them having paid as much as the value of the collection is. So you want to be careful about that. If there is going to be a protracted period of time that the estate is open, look carefully at those storage fees. The other side of that, though, that I really wanted to talk about is, remember when I talked about how NFA items, the transfer of them is heavily regulated? If a person, say, has a trust or they've got a will, either one, and so with an individually owned NFA item, the executor is legally able to be in possession of it. With the trust, the successor trustee is legally able to be in possession of it. If I want to transfer an NFA item to a licensed dealer, we have to do a Form 4 and wait 9 months to a year for it to be approved for me to give it to the dealer. You can't drop them off for consignment like you can regular firearms. That always floors everyone. Here's how a lot of dealers will sort of float past that. They will book it into their gunsmithing book, and they will clean and inspect the item while it's there so that it can be checked in for gunsmithing, which is not a transfer. That is a very gray area. Not all dealers are comfortable doing that. And you want to be extremely careful when you're talking to your clients, because I have had executors drop off NFA items at a local dealer where the dealer was unaware of just what problems they were exposing themselves to by putting it in their regular A&D book. So if you are an executor or a successor trustee of Title II firearms specifically, you need to store them where you are. That's really the answer.
And Joe,
Go ahead.
I'm sorry, somebody else asked a question that sort of piggyback off of that, so I'm sorry to interrupt, but they wanted to know. I can tell you my answer is no. Do either of you offer emergency or temporary storage of firearms?
Heck no.
I said no. I do.
I absolutely agree with you. I do not. Those are the persons that are empowered to be there. Even with regular firearms, I don't want to be involved in a bailment situation with the assets of a client. That's what the executor is for, and that's what the successor trustee is for. And I see we've got one more. Do you want to do that one, Jamie?
Yes, it says you mentioned an inventory requirement above. Is that a federal requirement independent of a state inventory requirement in probate? There is no requirement. So it's not required. There are only 6 states in which you're required to register your firearm. So no, it's not a federal or a state inventory requirement. It's just a best practices requirement. And I can't even say requirement, but it's something that I suggest to my client for best practices. And that way, especially if they don't have a trust or a will where they're outlining these specific firearms, when something happens to them, at least their loved ones can look to this list to determine whether or not, or to see what firearms they had. And as they sell them, of course, they can mark that off. They should keep all of that information in the same place. When we do trust, we also provide with them a list so that they can fill it out and just add to it or subtract from it. So it's nothing that's required by, at least by Georgia, there's nothing that's required. It's just the best practices.
Absolutely. I think we're almost at the end of the timetable, but we'll gladly answer any other questions that anyone has.
But as you pointed out, John, it appears that we are out of questions and we are out of time. So I again would like to thank both of our speakers for their wonderful presentation today. And I want to thank our audience. We hope you've enjoyed our national webinar, Firearms in Estate Administration, Legal Issues, Executor Liability, Transferring Title I and II Guns, Penalties. If your question was not answered, as John mentioned, you may email it directly to our presenters. Their email addresses are included in the presentation materials. If you are seeking continuing education credit, you must verify your participation in this webinar by completing and submitting the attendance affirmation evaluation after the program. A link to this form will be included in the thank you email that you receive immediately following the program. If you have registered and paid for this program by 5 p.m. today, you will receive your certificate of attendance within 24 hours. If you have any questions about continuing education credit for this webinar, please call our continuing education department at 404-881-1141, extension 2. Today's participants can order a recorded version of this event at a special attendee price. Please call customer service at 800-926-7926, extension 1, or visit Stratford's website at www.stratfordpub.com. If you're not yet a Stratford Annual Pass holder, try the CLE Individual Annual Pass. You can get all your CLE credits for one low price. Simply respond to the email you'll receive after the program. Stratford would like to thank you for your attendance. To end this call, simply close your browser. Thank you and goodbye.
Thank you for using the conferencing center.
And we are clear. Well done. I was a bit worried. No, your voice stayed great. Actually, it seemed to get better, but just needed to get the frog out of there.
That it was going the other direction.
Yeah, I know. When you guys were handling all those questions midway through, I was terrified that you were going to run out of questions and we'd have to milk it at the end.
We came close, but we made it. We slid in under the bar.
You did. Well done. Well done. So anyway, You guys should receive a follow-up email from Stratford, most likely with any report, the respondent's email, or I can read really well, I just can't talk. Um, the results of the survey. There we go. The follow up, the feedback, and with that, I believe there will also be a form outlining how you folks can apply for your own CLE credits if you so desire. Alrighty.
Jamie, it was
And
wonderful
you're still
meeting
muted,
you.
Jamie. Oh,
Thank you so much.
Thank you.
thank you. And now I invite you both to hit that little red disconnect and have a fabulous afternoon. And John, I hope your throat feels better tomorrow.
Oh, well, thank you both so much. Bye.
Bye-bye.
Take care. Bye now.